listen, you cannot put words into my mouth.
So, but allow me to make my...
And he told me that he has heard that he will be convicted for 20 years. He told me.
So that's... Oh, so you got it before the judgment was out? From who? No, this is a serious claim. He has just accepted that he got the judgment before the judgment was out.
So my reading of the judgment on the face of it, it's okay. It's okay. It's sufficient to put Wontumi where he is.
Abusia mama na wase na mema wakwa ba enradi see you TV through so dey na enye for dia go minia. It was the hottest debate ever and course so on TV3 na nkofo na omuwo program no so ba kun Lawyer Andy Appiah Kubi na woni chairman Wontumi court but eduru ba ebe no ohohoro nsa edi free sa Wontumi case no ema lawyer atachia ono nso eba betua so na Lawyer Martin Kpebu no nso owo show no so bi sanso na NDC MP Lawyer Hamza Suhuyini no nso owo show no so bi na binia de ekoba ye ene say Alfred Okansi na oye host ebisa Lawyer Andy Appiah Kubi say lawyer chairman Wontumi ye yantete ye sisi akoko piem ewo insawam prisons wone no akasa na de be asem na chairman Wontumi okaye eho na Lawyer Andy Appiah Kubi oba be kire mu say chairman Wontumi me no akasa na me ko insawam prison hokra akasa ekokosra no na nsem a me ne Wontumi ekokan ye de eye me ne Wontumi ye ntamu asem enye nsem o say Ghana for etibi eho na Alfred Okansi eto aso eka se ne ntima me bi sasa no yenya tete so babonten ebe kan se chairman Wontumi ansa na ne judgment no kora ebe ba no na ya sentence no obe kan se bi sa no pa no Wontumi efre wo eka kire wo se court ya awkoi on sign echi na ye bejere no 20 years asam no so ebaamu na nsem wo ye Wontumi okan yi na efrihe eho na Lawyer Andy Appiah Kubi o be ka se eye no kora se chairman Wontumi anopa no before so be court no be kan nsem se e de kire me okoye no so no esiye enuti medie ye evidence any ye grant e ko na court ene atemuo abayi de atwetwema so me ne court no enya adwen we eye nsem a Lawyer Andy Appiah Kubi okaye e de kire host no menua nsem no de oka bebre e be kwa hwe de video no na we na Lawyer Hamza Suhuyini awoye NDC MP no so oka kire Lawyer Andy Appiah Kubi se won nsem bi a wo ka no me ne wo enya adwen Supreme Court ewo ho Appeals Court ewo ho and say bia judgment na aba no only judge no enye adwenya ba bi e wo se wokọ eye court no na wakọ siki redress ba se bobet na political talk show so anase mo ko mountain so na mo ko yedede a na che say ye court no e na bugu hufi na we a senior lawyer you should know better and in same bia what ha wo kan de me na wo enya adwenya it was a serious banter between Hamza Suhuyini and Lawyer Andy Appiah Kubi Martin Kpebu so na watwako one corner but edru ba ebe no je mana konya se ono so onka no de ono de wo se asam no kra onya enkasa aye no odim se obeye bias nienti obeye bias no ene se ba ye nsuo ho nsem ka se ba ye flawless endi ye japade aye wo se ye mo ho banya e ho nsem ehia ne yie pa enti ono no de se obi ekoye saa ade no na se enye na se ye man 100 years kra ono Martin Kpebu no one court no ebeye adwen enti ono no de chairman Wontumi as a person ya che no atumu no enye ne de na emmom circumstances nam so ama Wontumi akoko piem ewo nsawam no de o ka se one court no enye adwen a na che se entro bi na odi enti ono no de judgment na aba no eye right say ya ma Wontumi 20 years na mpo no na nke betima ma 25 years na judge no ase Wontumi emobo na o ma no 20 years Lawyer Martin Kpebu ono so wa kire na dwen ebe kwa kope omu video no na answer ebe ko video no so no menua be kwa sa kunya wi so na masro se wunya en subscribe ye to this particular channel na wa subscribe e de ma me like video wi na share ma wi bi no so onya bi enhwe ma me na wase na yenko he video so no ebra ye ko ba ye beto aso nyakopon sira na won kan.
Have you visited your former client or is he still your client? No, he's still your client on some cases.
In other cases, yes.
Yes.
You see,
have you visited him?
I have visited him. He's doing well.
When?
Yesterday.
He's doing well.
He's doing well. He's doing well.
Did he tell you anything at all?
No, that was a conversation between client and lawyer. We're not supposed to discuss.
No, I'm asking you this because you see, the day he was imprisoned, I spoke to you, and you said on the morning of the day he went to prison, he called you, and he said you should do what?
Indeed, I told you, and I still stand by that, and that is the fact also. he told me that he had prior information that he will be convicted, and therefore gave me instructions first after the conviction.
I see.
And this is a fact.
He had prior information that he was going to be convicted on Monday.
And again, I am going to show you why probably he had that prior information. This is a copy of the judgment. Look at it. Judgment didn't go to even the registry of the court. So there is nothing to show that there is. This is on a regular A4 sheet. The courts have their own sheets that they use in publishing judgments. So there is no indication of the stamp of the registry. You go down there at the end of it, and it says that counsel, and in this particular case, defense, attachment for the first and third accused persons. Attachment was not in court on the day. So it would have been that Mr. Appiah Kubi holding the brief of Samuel Attachment.
But you were not in court on that day.
No. I'm saying
you're just saying that example.
Somebody else. But
even before we get in
somebody else held the brief on the day.
Right.
So ordinarily,
the person's name
will come, and then you refer to the lead counsel or the senior whose brief the person was holding. This is a publication that came even before the judgment.
Did you ask that's Wontumi further on Monday why he suspected that he was going to be convicted on that day, even before he went to court in the morning?
I'm saying that he probably had a copy of this before the judgment.
He had a copy of the
judgment before it was delivered. And I'm justifying that with these observations.
I wanted to find out from you, see, the narrative that has been put out about Chairman Wontumi's imprisonment is that he's a political prisoner. You handled this part of this particular trial. Do you agree with that?
I agree that the evidence on record cannot support the verdict.
Is he a political prisoner?
Well, I'm saying, I didn't see any politics in the records, but what I'm saying is that the judgment cannot be supported by the evidence. That one is, and that is in any case, that is how I will interpret the situation. But again, subject to three wise men who also look at what we are all saying. But I'll be firm in my conviction that the evidence here in this records cannot support the conviction.
I have listened to Senior Andy Appiah Kubi, and I'm left with one irresistible conclusion on this matter. And that is the unfortunate level of dishonesty characterizing. No, I'm coming. Please, hold on, please. The unfortunate level of dishonesty that characterizes our political discourse, and most importantly, especially when it comes to judgments of our high courts. And I say so because, first, a claim has been made by a judgment that Senior Andy is brandishing everywhere.
We're brandishing everywhere.
But you just did. But
you say everywhere.
Please.
It is on this.
Hold on.
Not everywhere. Let me correct you, please. Okay. Brandishing everywhere. What does that mean?
All right.
It means I'm doing it not on one forum. Everywhere means everywhere.
Claiming that this.
But I've just done it here. So say it on this platform.
No, Hamza, let me hear you.
Claiming that this is a document that emanates from the High Court judge, and that it was not signed, it was prepared ahead of time, and to the extent that this is a document that is not signed, it presupposes that...
I did not say it is not signed. Please quote me well. I did not say it is not signed. I said that, you see, there is a...
There's no court stamp.
He said it's not been certified.
I said it's not certified. That is not signed.
That's the
certification is different from signing. Please, let's get our words. We are talking.
You said it was not stamped, not so.
I say it was not certified. Yes,
they are close.
But I didn't say it was not
stamped. So first of all, this is the first time I'm hearing this, and this is your claim. We all know how we get judgments from the courts.
Yes.
I don't know how you got your judgment, but I'm pretty much convinced, the information I have, that those claims are unmeritorious.
Those which claims?
That the judgment was Wontumi probably had access to the judgment before he was sent in there.
Am I not showing you this?
And you have, but the judgment is now out. So what are you showing?
Yes, so go and find the judgment and compare.
But you made an assertion that the judgment was out even before the DD.
And that is why I'm showing you this.
Oh, so you got it before the judgment was out? From who? No, this is a serious claim. He has just accepted that he got the judgment before the judgment was out.
I am saying that
liable for that. And are you saying you got this judgment before?
That's what he said. He has just said.
His mother gave
No.
Let him be liable for that.
I'm making my point. Yes.
I'm saying that even my mother in my village knew about it.
Okay.
I didn't say,
No, but he has just accepted now that he had this before the judgment came out. Oh, this is my playback.
No, wait.
No, it's okay.
Did you get this judgment before it was delivered?
I got
Monday?
the content from Chairman Wontumi before it was delivered. But immediately after the delivery, I got this also I pulled it from the internet. You understand? But before it was
Can I make this? I think that our viewers are better judges.
But I'm saying that unless you discredit this.
I see.
Please let me make myself.
You got the content of this from
I'm
Chairman
telling
Wontumi.
you that Chairman Wontumi himself called me 3 times before he entered the court.
And gave you the judgment.
Listen, you cannot put words into my
So, but
mouth.
allow me to make my
And he told me that he has heard that he will be convicted for 20 years. He told me.
So that's the content is referring
Yes, that is the content I'm referring to.
No, he said the content.
I got it before the certification.
Before the certification, I think. No, Justin, thank you.
I am saying
it was the actual judgment.
The sum total of the judgment is that he will be sentenced.
Let me hear you.
That's the content he's talking
And
about.
again,
Okay,
Can I make this? We can allow you to run. That is one. Another interesting claim was made to the effect that indeed even the charge sheet was defective.
that's what I'm reading.
Yes, and I'm not disagreeing with your opinion on that matter, but I'm also just asserting that any lawyer worth his salt, if you have suspicions that a charge sheet is defective, there's a process that you have to kickstart to challenge the validity or otherwise of that charge sheet. Was it done?
Go and read the address. Go and read the address. You will see it.
You are restrained. Please. Thank you.
When you say a lawyer worth his salt, what case have you done in your life before?
When you were talking,
when he says,
nobody interrupted
again, you should control his language.
Well, you were the lawyer who was supposed to challenge it. I didn't know.
Worth his salt. And you have not seen the challenge even on the charge sheet, and you are talking like that.
Challenge on the charge sheet. You challenge it on the charge sheet.
I think
That's not what I was
in the
told.
courtroom. The motions that he been filed, you
Let
don't
me just give you a classical example. In relation to Hannah, that is not true. Both in the UK and here. And let me make my point. Let me
say a lawyer
Make your point.
Are you going to allow us to have a decent show?
Make your point.
Make sure that you also be decorous. A lawyer was his salt, indeed.
Oh, you should have been decorous in assessing the judgment of the judge. You sat on TV, a senior counsel, and sought to impugn the integrity of the judge by alleging that she released her judgment. And you think that is an example for me, a junior counsel, to learn from you? What are you talking about? Please. And you see, first of all, I have demonstrated that the reasonable thing to do is to challenge the validity of the charge sheet. If you thought that there was something wrong with it, we saw it not long ago, 2 or 3 days ago. The Council of Hannah and Aluduba, when they had concerns about the charge sheet, they did the needful by going on motion on notice to challenge same. That is what any lawyer would do.
So is it conclusive that you only do that?
You made your point.
I had strategy. I wanted to challenge it in the address. You haven't practiced. You don't understand. No, he doesn't understand. What said the only thing to do is to challenge the charge sheet. And it was not my strategy.
You're being destructive. Let's maintain some decorum, please.
So, again, another interesting claim to the effect that, when it comes to the concerns that were being raised, the circumstantial evidence adopted by the judge, it is interesting that he actually even didn't seek to challenge the essence of using some circumstantial evidence when it comes to criminal trials. Because he cannot. One, if you have a witness before you, and the witness has made assertions to the effect that per his arrangement, and mind you, even before that, you presented a prosecution witness to the judge, an expert witness, an accused witness, and indicated to the judge, senior, that look, this is the person who is vested when it comes to reclamation. And questions were asked on cross-examination about the financial implications of reclamation. And your own witness accepted on oath that indeed it is not, we are not talking about small monies when it comes to reclamation, though he fell short of mentioning an amount. Yeah. And a direct question was asked to you, your witness, as to whether indeed there were any financial commitments in that regard, whether Wontumi had paid for it. Wontumi had not paid. And so all the questions that were asked on the stand were questions that made it easier for the judge to connect the dots and cross the T's, and came to the irresistible conclusion that, look, Wontumi engaged with Henry Okume & Co. with the sole motive of actually engaging in illegal mining, intending to benefit from the process of that illegal mining, but not reclamation. It is one thing for Wontumi to claim that I sent him there for reclamation. It is another for Henry Okume to also claim that I was sent in there to reclaim and to mine. But at the end of the day, it is not Senior Andy Appiah Kubi or Atachia who is vested in law to compare the two scenarios and reach a conclusion. It is the judge. And the judge will reach a conclusion based on examinations in chief and cross-examination and evidence available. So if at the end of the day, the judge listens to both sides and came to the conclusion that indeed Wontumi had questions to answer and proceeded at the back of that to reach a conclusion, I don't think that we can sit on this platform and say that, look, the conclusion was not sound without challenging it in the form of an appeal. My senior also made references to piercing the corporate veil and said that, oh, it is only applicable in civil matters. That is not true. Because even if a company commits a crime against the state and the state takes steps to ensure accountability, the law permits lifting of the corporate veil to go against directors of that company. So it is not accurate to claim in law that the issue of lifting of the corporate veil is only applicable when it comes to civil matters. That is not law.
Absolutely.
That point needs to be made. And we see there is also an interesting logic, especially when it comes to this case, and it has been demonstrated. You can see the tension between Senior Appiah Andy Kubi and that of the MPP, because they believe that he didn't do a great job. And you could see even the arguments between him and that of my brother Richard on this platform. But the reality of the matter, we can all pretend as much as we want. Evidence was presented. They were weighed. A decision was made. If you have any problem or whatsoever in relation to the decision, the appeal processes are not shut on you. And I've heard them make reference to the fact that, oh, even they were challenged, they were seeking for an interpretation and the judge proceeded to rule.
Yeah.
Richard, that is another problematic assertion and misunderstanding of the law. It is true that prior to ex parte Senator and Co, the position of the law was to the effect that lower court judges, no, I should say from the high court, they were allowed to more or less apply the law in the way they understood it. Especially people were alleging issues of interpretation that was in actual sense not interpretation. But even prior to ex parte Senator, I remember the case of, there was a case from Mekankan from the 70s. It was more or less influenced later on by even the Richard Anani case. The interpretation of the complaint in the provision of the act. Complaint. It was indicated in that decision that, look, judges must be more than willing to refer to the Supreme Court. But that does not also mean that when they look at the law and it is clear on the face of the record and that they can apply, they are precluded from applying. Right. They can proceed to apply. Yeah. So if the judge has applied The judges, it is your word against the judge's word.
True.
The judges feels that this is not an interpretation matter. Even ex-parte senator did not say that the judge has no right to apply the law. Indeed, if you read the law, that judgment, it was clear that judges are allowed to apply. And so if you have issues, you can even raise the matter of interpretation for the first time on appeal. I'm a Lion Senior. Republic versus Dexter.
No problem.
You have the legal case gives you the authority to raise the issue of interpretation for the first time on appeal. But the point I need to make is that, look, the MPP should not use their internal confusion, as far as this Wontumi matter is concerned, and transpose that onto our judicial architecture to give an impression that there's something wrong with the judgment. What is wrong, as far as this issue is concerned, is their internal confusion. And so it must be separated. But if you read the judgment and you follow the case, the conclusion was irresistible. And those who are claiming that they have identified in excess of about 20 grounds of appeal, let them say it on this table. People are making references. People are making references to charge sheet and how defective it was.
So let's do this. So there's naturally bias on my part. So if you say there's a defective, any defective,
this discussion of Wontumi
as
a political prisoner. And so let's
So the first part, I think, is there any defect in the judgment? I'm saying that because of my bias, you won't expect that I'll do an excellent job at it. The bias being that we need to protect the forest, etc. So my reading of the judgment on the face of it, it's okay. It's okay. It's sufficient to put Wontumi where he is. It's sufficient. It's sufficient to put Wontumi where he is. Because, you see, the thing is that the judge makes the reference. Keaton, Wontumi does not deny that he gave permission to Henry Okum, right? But that permission he gave, wrong permission, because the person who was giving the permission to Henry Okum does not have a mining support services license. You see, before you do mining support services, you have to be licensed. So he was engaged in an illegality by giving that to Henry Okum. Okum told the court that he is a small-scale miner. He's not into reclamation. Reclamation is a science, so it's not just you just cover the pits and start planting.
But the reclamation has to even be approved by the ministry.
That's what I'm saying. Yes, so it's a whole procedure and the LI. If you want to do reclamation
to the ministry.
So it will be won't be the owner. Or you mean for the license? Yes. The license should be Henry Okum. And if you are going to engage somebody, you should be checking whether he's licensed for that purpose. It's just like you're going to hire a lawyer. You've not checked whether he's licensed. Anybody is seeing the court premises, and in a suit, lawyer, can you help me? No, you first check. Are you a lawyer?
So that
are you a lawyer?
To will not say that I am not qualified.
He says his story is that Wontumi gave him for them to mine.
The person who wrongly engaged the wrongful person is rather guilty of providing the service than the one who did not have the qualification.
Yes, because of plea bargaining. So when they approached Henry Okum, he decided to cooperate. You think if Wontumi had cooperated, it would have been this high?